morning and welcome to the Court of Appeals. I want to take just a moment before we get started and just make sure everybody's on the same page as we proceed today. I know everyone's an experienced practitioner, but it's one of those things that I like to do. First of all, let's talk about our procedure. Obviously, everybody understands you get 15 minutes to make your oral argument. If you are the appellant and you wish to reserve any rebuttal time, please request that from the court after you've come to the podium and introduced yourself, but before you begin your argument. You may reserve up to 5 minutes of rebuttal time. If you're the appellant, appellee gets no rebuttal time. We have a lighting system on the podium. I believe it to be very straightforward. Once you begin your argument, the green light comes on. Once your time is running short, the yellow light comes on, and when your time is used up, the red light comes on. We ask that you please respect those time constraints. One very important thing that I want everyone to understand is that these arguments are being live streamed. The important thing from our perspective is please think about what you're saying as you say it, because once you've said it, it's out there in front of everybody in the entire world, or that possibility is there. So please think about that. Your panel this morning consists of Judge Kenny Armstrong from Memphis, Judge John McClarty from Chattanooga, and I'm Steve Stafford from Dyersburg. Ms. Ashley, anything we need to take up before we call the first case? All right, you may call the first case, please.
Jack Scott v. Tennessee Department of Transportation.
Good morning, Your Honors, and may it please the Court. My name is Ryan Henry, and I represent the state of Tennessee on behalf of the Tennessee Department of Transportation, appellant in this matter. Before I begin, I'd like to reserve 2 minutes for rebuttal.
2 minutes. All right, you may proceed.
Your Honors, the issue in this case is whether the Board of Appeals properly upheld the Tennessee Department of Transportation's decision to terminate petitioner's employment for failure to maintain satisfactory working relationships and failure to report for duty at the assigned time and place. I will provide a brief background on the procedural posture of the case and then provide 2 arguments explaining why this court should reverse the Chancery Court's order granting petitioner's motion to alter and amend and uphold the Board of Appeals findings on the merits. This matter is governed by the TEAMS Act, which requires that the appeal of an employment decision go through 3 steps of review prior to being eligible for judicial review. The first step is a review by the employing agency, here TDOT. Step 2 is a review by the Commissioner of the Department of Human Resources. Step 3 is a review by the Board of Appeals. At that point, an unsatisfied party may appeal for a judicial review by Chancery Court.
Is that an evidentiary hearing?
Excuse me, Your Honor?
Is that an evidentiary hearing? When is a evidentiary hearing conducted in this process?
Step 3 is an evidentiary hearing.
With the administrative law judge presiding?
Yes, Your Honor, as well as a panel of commissioner board members.
Okay, and who makes the decision in that situation? Well, you've got board members and you've got an administrative law judge. So who's the fact finder?
Excuse me. The commissioners are the fact finders. The ALJ is there to preside over these proceedings and ensure that they proceed according to civil procedure.
So the ALJ doesn't make any decisions other than the procedure or evidentiary rulings?
That's correct, Your Honor.
Okay.
So the commissioners make their decision based upon the evidence that's presented to them?
Yes, Your Honor. During the Step 3 Board of Appeals hearing.
Then their decision then will be that based upon and nothing other than what is they actually receive as evidence and whatever they view as evidence. Is that correct?
Yes, Your Honor. There is a technical record that is available for review, but the documents in the technical record are not admitted as evidence unless moved into evidence by a party. Otherwise, the evidence consists of what is put on as testimony at the Step 3 hearing before the commissioners.
Well, in this particular instance, apparently the ALJ ruled that some evidence should not be included or should not be considered, correct?
Yes, Your Honor. There was a motion in limine by petitioner which requested that a specific exhibit on the state's case list, the inmate charge history, be excluded from evidence. That motion in limine was granted, and the document was excluded from the record.
So did the commissioners consider that?
Your Honor, the commissioners did not have the inmate charge history available to them, and they did not consider it in their decision. The Step 3 Board of Appeals hearings are a bit unique in that you can see the commissioners' deliberations are on the record. So if you look at the commissioners' deliberations, none of them mentioned an inmate charge history, and it was not in the record. So there's no evidence that it was considered in the findings.
Well, there must have been something because the administrative law judge gave a curative instruction to not consider this evidence of the appellee's arrest. So how did that arise such that it was necessary to give the curative instruction?
Yes, Your Honor. The Step 1, Tennessee Department of Human Resources is required by statute to provide the Step 1 and Step 2 decisions and complaints to the Step 3 board prior to the hearing. The Department of Human Resources complied with that statute, provided the Step 1 and Step 2 decisions and complaints, and the findings of facts in those decisions referenced an inmate charge history. But the inmate charge history itself was excluded from the hearing.
So the Step 3 hearing then, was there any mention of this excluded evidence other than the ALJ saying we're not considering it by either the ALJ or the commissioners other than the exclusion itself?
The Assistant Human Resources Director for TDOT gave testimony at the Step 3 hearing. At the conclusion of her testimony, the commissioners are permitted to question each witness, and a commissioner attempted to elicit testimony about the petitioner's whereabouts from January 27th to February 3rd. And the ALJ properly stopped the line of questioning immediately, had a sidebar with the attorneys, and then gave a curative instruction to the commissioners.
Was there any objection to the content of that curative instruction by the appellee?
There was no objection by the appellee to the content of the curative instruction. There was an objection by the appellee to the line of questioning in general. However, the ALJ appropriately handled the situation by stopping the line of questioning immediately and giving the curative instruction. For a bit of context, this was 3 lines in a 243-page transcript. So looking at the totality of the evidence, the mention of petitioner's incarceration was extremely minor.
Assuming that was a significant enough issue or error, something that had been raised that shouldn't have been raised, that was a major issue. Can you have I guess for want of a better description, a mistrial or impanel other commissioners? Is there a procedure for that?
Yes, Your Honor. The ALJ could have declared a mistrial. However, the board would have to be reconvened within 120 days of petitioner's complaint. The ALJ noted that that was not a possibility and that the curative instruction was sufficient to move forward with the Step 3 hearing.
Was a mistrial requested?
There was not a formal request for a mistrial. However, petitioner's counsel indicated that had this been a jury trial, he would have been moving for a mistrial. The ALJ did specifically address the issue, that he treated that comment as a request, denied the request, and moved forward.
Okay.
And as far as the mistrial standard, Your Honor, 2 of the 3 factors for a mistrial weigh in the state's favor. So in looking at whether a mistrial is appropriate, the court would look to whether who elicited the testimony and whether there was a curative instruction. In this case, a commissioner elicited the testimony, not the state, and the judge gave a prompt curative instruction, which is presumed to be followed.
So I'm assuming the entire record moves forward to the trial court then. Is that right?
The entire record?
Of the level 3 hearing or stage 3 hearing, once the matter gets to the trial court itself?
Yes,
the
Your Honor.
Chancery Court here. The entire record moves forward. Is that correct?
Yes, Your Honor.
Was there any requirement, need, or attempt to redact the record, to remove this mention of the excluded evidence, or is that necessary?
There was not. Petitioner was free to file a motion to redact the evidence from the record during the Step 3 hearing. He was and he did not do so.
Is there a need to do that, since it's been excluded from consideration by the commissioners?
I don't believe so, Your Honor. This court's review is on the record, and that is because petitioner did not redact the record at the Step 3 Board of Appeals, it would not be appropriate I don't believe it would be appropriate to redact it at this level.
Isn't the Chancery Court's review the same as ours?
Yes, Your Honor.
So, here. What else is it that Hearing 3 panel or the administrative law judge could have done in this situation?
I have 2 answers for you. The first and obvious answer to me is once the trier of fact is tainted with prejudicial information, it's a mistrial.
Was that asked for?
I'll read exactly what happened there, Your Honor. This is from page 263 of the record, or excuse me, 262. Nope, 264. Here we go, 264. Your Honor was clear that day that was not to be brought in at all. I mean, it clearly was. What's the point of having a de novo hearing if they're repeating everything that's already happened, prejudiced? And then he does ask, he says, I would, right here on page 263, if it was a jury trial, I'd be moving for mistrial at this point. You made a clear ruling, and now we're at this point at the very last minute. And the judge says, I understand your petition, and as counsel said, he essentially treated it as a motion for mistrial and denied it. And the reason he denied it was not to protect petitioner's rights. The reason was I don't have a way to reconvene, this panel within 120 days. Well, that's unfortunate, but he's trampling on petitioners' rights because they don't think they can reconvene. in
Was a
120 days.
mistrial requested?
Yes, Your Honor, I believe it was. I believe the record is clear enough that what he said is.
Well,
a
he
request for
said
mistrial.
I would ask for one. Did he ask for one?
I read what was asked, or what he said. I would submit that that is sufficient to request a mistrial. It certainly is enough for.
And that you have the transcript. Can you read to us what the commissioner said regarding this arrest that led to the curative instruction in the side panel,
I can read,
sidebar?
I will read what the administrative judge said in response to this request for mistrial, and then the curative instruction that he gave.
No, I'm
Oh, okay.
interested in the question asked by the commissioner. What did the commissioner ask?
The commissioner asked, was one of the things that troubled TDOT with regard to the absences from January 27th to February 5th an issue that Mr. Scott may have been incarcerated for part of that time? Administrative judge responds, all right, there have been some pre-hearing discussions about that information, and it was ruled to be irrelevant, so it needs to be so it's not part of the information that the board needs to consider. Then there's a sidebar, and after the sidebar, he gives the following curative instruction. Mr. Manuel, you were asking questions. That last question you asked is one that concerned information that's in the technical record that's not relevant to the charges, the only two elements, and it must be disregarded by the board. Do you have further questions? He doesn't say why, he doesn't say what about it is irrelevant, and even worse, later on in his instructions to the board, he says, you may consider the technical record.
And there was no objection to the curative instruction?
No,
No
but
request
the
to
judge-
modify it, to expand it in any way?
There was not, but again, the judge didn't give them an opportunity. I realize counsel could have said, hey, Your Honor, that's not enough. I see I'm out of time. But to answer the question, he could have said, that's not enough, but the judge didn't give them a chance. He didn't discuss the curative instruction with them. We would just submit that the Chancery Court was correct in saying, and this is, I'll point to the Gordon case.
You've used your time.
I have, Your Honor. I may file a notice of supplemental authority because it's a recent decision.
Thank you.
Thank you, Your Honors.
Your Honors, I have 2 points on rebuttal. May I begin?
Go ahead.
First is that the Step 1, Step 2 decisions and complaints were properly in front of the Step 3 Board of Appeals pursuant to Tennessee Code Annotated 83318 I-4, which requires that those documents be provided to the Step 3 Board of Appeals.
Did those documents reference the incarceration?
Yes, Your Honor. However, those documents have to be were transmitted prior to the motion in limine hearing. TDOT and the Department of Human Resources could not have redacted those documents prior to submission to the Step 3 Board of Appeals. My second point.
Could the ALJ then have ordered that the documents be redacted?
Yes, Your Honor, at the motion in limine hearing.
Did that happen?
Petitioner did not ask for any redactions to the Step 1 or Step 2 decisions and complaints.
But they did ask for exclusion of evidence.
Yes, and for a specific document, the inmate charge history, which went into detail about the criminal acts that petitioner engaged in. That document was excluded from the record and was not considered by the Step 3 Board of Appeals. And if you look to the record.
When you say excluded from the record, do you mean it was physically removed from the record?
It was not transmitted to the Step 3 Board of Appeals.
Okay.
And
The Step 1 and 2 decision, was there any mention of the incarceration in their decision itself?
it was included in the findings of fact. As far as the analysis of the decision, it was not mentioned in the Step 1 or Step 2 analysis supporting Tennessee Department of Transportation's termination of petitioner's employment.
right, thank you.
Thank you, Your Honors.
Thank you, counsel.
We appreciate your arguments, your briefs. We'll take this matter under advisement and attempt to render an opinion at the earliest possible time. Thank you. You may be excused.